Hello, everybody. This is Keith Caldwell with Failure Plan, and I also got with me Ryan Platt. Why don't you introduce yourself, Ryan?
You got it. I'm Ryan Platt with a special needs plan. We're an organization that serves families in putting plans together so that their child with special needs is always taken care of, no matter what.
Excellent, excellent. Now, Sherry, we had a question from one of our people following us, Sherry Struggs. Ryan, why don't you go ahead and read that question and go ahead and answer it. I told her we were going to answer it for her.
Absolutely, yeah, I'd be happy to do that. So Sherry asked us a question on the community on Google Plus, our special needs children. Do you have any suggestions on where to open the special needs trust account? My son's special needs trust will be funded by the proceeds from my life insurance, but shouldn't I provide deposit instructions with my will? I'm having a difficult time. So, you know, Sherry, we certainly appreciate the question, and there's kind of I guess an interesting way that I want to answer it. It's almost a twofold answer. One is and I'm going to make some assumptions here, everybody, so please, one, Sherry, if you're listening and I'm not right, you know, let us know. But based upon how you frame the question, I'm assuming that the special needs trust does not exist right now, but it only exists in your will. And what I mean by that is when you set up a special needs trust, you can set them up kind of two different ways. One is called testamentary, which means that the special needs trust only lives in your will. So it doesn't exist until you as the parent don't exist, right? It doesn't come into existence until the parent goes out of existence. And so it lives in your will. You can't put any money in it while you're alive. You can't set up a trust account yet, because it doesn't exist, and it will not exist until you're gone. And so if that's the type of special needs trust that Sherry has, and it only exists inside her will and only pops up after she's gone, then there's no trust account to set up. We can't set one up because the trust doesn't exist yet, because Sherry's still here. And so that's one type of special needs trust, or one way to set a special needs trust up. The other way to set it up is what they call inter vivos. And inter vivos is a fancy Latin term that my mother would be disappointed in me, I think, because I took 5 years of Latin, and when I first heard that, I had to go look it up because I didn't know what it meant.
Right.
What I found out that it meant between the living. And I've been speaking English for 40 years, and I didn't really understand what that meant either when I first heard it. But what it means is that it's alive today. So it means that the trust is set up as a separate entity. It doesn't exist just in a parent's will. Okay? It exists on its own. It's a separate live entity that gets its own tax ID number, or in more terms that we all understand, basically a social security number, so that you can actually open up an account, whether it's a checking account, a savings account, an investment account with mutual funds and stocks and bonds, whatever that is. It has a tax ID or a social security number to it because it's its own entity. You can almost think of it as its own person. And so if you have one of those, Sherry, if you have a trust that's already a standalone, we kind of call it as well, you know, it stands by itself because it doesn't have to do with your will, is if you have one of those, an easy thing to do is, one, make sure that your executor knows that it's there, and the executor, I'm sorry everybody, the executor is the person that you write in your will who's going to administer all your wishes inside your will. And we'll go into that a little bit later as well. You could let them know, okay, here's the trust, here's the tax ID number. One thing that we are that we prioritize for people, or not, I don't want to ever say force onto people, but one thing that we're pretty strong with is kind of a communication plan when you have your your plan complete, and we're going to talk about that in our last 20-minute segment of our series that Keith and I are doing together. But one of those pieces is called a life journal, and that's the instruction manual to the next caregiver. In that document, one thing that you could do, Sherry, is inside that type of a document, you can write down for the next caregiver, okay, here's the trust, here's the name of the trust, here's the tax ID number that I've already got. Again, very easy to do. It's not hard to get that tax ID number. You don't even have to set up an account yet if you don't want. You just get the tax ID number, you put it in this document, you make sure that next caregiver has it, so that when those life insurance proceeds, like you said, Sherry, yours is going to be funded by a life insurance proceeds, when that money comes in, that next caregiver very easily, or whoever the trustee as well, it may be the same person, the trustee of the trust, and we're going to go over all these terms in a minute, can just go to a bank or an investment company and say, open this account, just do an account application, here's the tax ID number, here's the name, and here's the check to fund it with. And you can do that all in the same day. Now, if you don't have that standalone or inter vivos type of trust, and it lives in your will, then what you're doing is you're leaving all of that to the next caregiver support team that you put together, right? The guardian, the trustee, the executor of the will. You're leaving all that responsibility to them, meaning, okay, the trust is going to pop up. That means I got to go get a tax ID number. I have to wait to get that tax ID number back. Again, it doesn't take long, but it takes a couple weeks, right? So they're holding this life insurance check maybe, or maybe it gets there at the same time. And so they're going to wait and hold the tax ID number. They're going to apply for it. They're going to get it back. Then they're going to go open up the account at that moment. So it can work either way. What we always think about is, again, every family situation is going to be a little bit different. And again, as I always say in all these things, please don't go out and just take what I say and just go do it. You know, please don't take any of these as recommendations for your specific family. But for the majority of families, that standalone or inter vivos trust that's alive today is very flexible for families. And here's what I mean by that is especially if you have extended family members like grandparents or aunts and uncles that may leave money for your child that has special needs. Well, if you have that testamentary trust that just lives in your will, and you know the grandparents who are a generation older than you as the parents are, they're probably going to die first, and if they have any money they want to leave for your child, they can't leave it anywhere, right? Because that trust doesn't exist because it only exists in your will. So if you had one that existed already, that standalone trust, then it would be prepared and ready for dollars to go into it. So a lot of times that offers a lot more flexibility. It allows you as the parent to prepare that account before you die, right? So for example, Sherry, again, and I know I'm using your name again, but you asked the question, and we appreciate the question very much. So I'm going to kind of focus these answers to you, and hopefully they help everybody else as well. If you have that standalone trust as a parent, well, you could take it a step further and say, you know what, I'm going to get the tax ID number. I'm going to open up a savings account at a bank. It doesn't have to be a lot of money, right? I'm going to take $250 and I'm going to put it in that trust and just have it open. And then it's totally ready to go. You know, that the trustee or the next caregiver, the executor, when you pass away, doesn't have to open any account. They don't have to do anything. They just bring the check and dump it in, right? You could do that with an investment account, with mutual funds. You could do that with whatever you want if you're in a position to be able to do that, right? If you're in a financial position to be able to do that. The one thing we always want to be careful of is, for a lot of times with parents, you know, your money is your money, right? You're using it for everybody in your family, right? You're using it for your needs. You're using it for other children's needs if you have them, and you're using it for your child that has a diagnosis, right? Once you put money in that special needs trust for them, you can't use it for any other purpose. So if the shingles fall off your roof and you need to use money to replace them, and you put all that money in the special needs trust, you can't take it out for that reason. Or else you lose the qualification of it being a special needs trust. And then it counts as an asset towards your child, which then could put in jeopardy the qualification for the government benefit programs that we want to try to make sure occur for you. So you want to be real careful as a parent and as a family that if you put any money in that special needs trust just to have it open, right, to make it easier for those next group of people when you die to come around to make sure things are smooth for them, just make sure you put in enough to open it and enough where you don't have to use it, if that makes sense.
Yes.
And so, Sherry, I don't know exactly if I gave you a good answer or not.
I think you did.
But it kind of depends on.
Why don't we go ahead and move to the gist of our conversation? I think that was a good start, and it covered a lot of things that you're going to cover. I know we're talking about advanced directives. What are they, and why are they important to us?
Yeah, I think one, let's kind of, because I know there's always a lot of questions on kind of the legal pieces. So some of the legal pieces that you want to think about are, we mentioned the word will already. Well, if you think about a will, that's kind of the cornerstone of anybody's kind of legal, if you want to call it legacy planning or estate planning that they have. And what a will does, I always say, to simplify it, it really does three things, right? One, it tells your executor or the person who's going to administer it for you, it tells the court system who that person is. It tells the court system where you want your stuff to go, right? All your assets, where are they going to go? And then it tells the court system where your people go, right? Who would you like to take care of your children, right? Now again, if all of your children are minors, that becomes very, very important, right? If you have adult children and one of them has disabilities, then that's still going to be important for your child with a disability if you are their legal guardian.
Mm-hmm. I can't hear you. Ryan, I cannot hear you. I don't know if you can hear me. Can you hear me? Nod your head. Okay. Look for your, maybe you hit the mute button. That's really strange. Hello, hello. Just 1 minute, everybody. We're trying to get this figured out. Just 1 second. Technology, technology.
Oh,
Yeah, I can hear you now.
okay. I don't know what happened there.
It's called user error, Ryan. I'm just
Sorry
kidding.
about that.
That's all right.
Sorry about that. The and so that will's gonna kind of do those three things for us. And so that's going to be important to let the legal system know what your wishes are in a general way. Another piece to that plan is that special needs trust that Sherry asked a question about. And that special needs trust, as we already said, one of the main reasons for that is to be able to continue to qualify for government benefit programs that are financially needs-based, but to do so, we basically have to impoverish our children to do so. So a special needs trust allows you to keep resources that are available specifically for them, and if you have them in this correct type of trust, then the government doesn't count it as a resource that your child owns. Right. So therefore, you could have $500, $1 million, you could have 50,000, you could have 25,000, really whatever you want in that special needs trust. You could have a house in there, you could have collectibles, assets, rental property, almost anything you can own as a person can be owned inside of a special needs trust as well. And so you can have that as part of your planning tools, and it allows you to provide more resources for your child's lifetime and yet still have access to government benefit programs as well. So that's one of the main reasons for it. You have to be real careful with special needs trusts. You want to make sure they are assembled by an attorney that does them on a regular basis. You really want somebody who, like I said, does them. If they do at least every week, that they're doing special needs trusts. Not once a month, not once every quarter, not once every 2 months, but doing them, on a pretty regular basis. Because they are unique and they need to be done correctly. The other piece of special needs trust that I'll touch on is you also want to make sure that they not only have to be written correctly on the front end when you design them and write them initially, but they have to be managed properly on the back end. So when you choose someone to be what's called a trustee is the person that I always say they kind of have 3 jobs inside the trust, right? They're in charge of the assets inside the trust to make sure that those assets last as long as possible for the benefit of your child. They're there to make sure that they prepare tax returns and tax documents for the trust, because it does, like I said before, have its own tax ID number, so it'll have its own tax return. And then they're also responsible really for understanding the distribution rules of a special needs trust. And that is extremely important, because if you set it up correctly, you want it to be managed correctly. And interestingly enough, I was just meeting with a family that's had a special needs trust set up for a while, and it's being managed by just their regular financial advisor. And as they're telling me how they're using it, they noticed on my face, I guess my face told the story of concern that I had, because they're mixing monies. They're having, his Social Security dollars come to his checking account, then he puts it in his special needs trust. He's got other dollars coming in that he's mixing in there, and although the trust was written correctly, the money coming in and out is absolutely wrong. And that's going to cause major issues in terms of Medicaid and payback rules to Medicaid and qualification purposes. So when you set these up, you need to make sure that you have a trustee, and if it's a family member, that you give them some kind of education in terms of, okay, you need to go to this group to help you manage this and the distribution rules, because very rarely does a family member know, one, even how to set it up, right? You wouldn't know that either, but how to manage it. And probably your regular financial advisor may not, probably doesn't have that expertise because they don't manage many, if any at all. And so they don't understand what you can pay for, what you can't, whose money can put into it, whose money can't be put into it, when you take money out, who can get the money directly, who can't. So it's very important to understand the piece and think through that as you're thinking about, okay, who's going to manage this trust? Who's going to be the trustee? And do you maybe not only want to have a family member as a trustee, if that's what you're thinking about, but also think about having an administrative manager to kind of be a check and balance for your family member trustee to help do those other three jobs of making sure that they watch over the management of the money, do the tax return, and understand the distribution rules, while your family member trustee can really focus on making sure that the money is used to provide the kind of life that you want for your child. Right? Because they're the ones that's going to be touching your child probably more than an administrative trustee would. And so you may want to think about that kind of a design. Again, every family is different. You can design a trust in so many different ways that would fit your family. So it can be a I don't know if this is the word that everybody would use sitting out there, but it's kind of a fun process to kind of design it. Yeah, everybody's like, "Are you kidding me? Did he just say that?" Because every family is unique, you can design it to really be tailored for exactly what you want it to do, and to have those positions filled by, whether it's family members or outside the family, to really make sure it suits what you want to see happen. Some of the other pieces that you want to consider as well are some of those what we call advanced directives, which one thing that we always put in that category are kind of a living will, right, for parents. If all of a sudden, you all of a sudden, and Keith will tell this story another day. He tells it before, but if all of a sudden you have an aneurysm, or you have a stroke, or you have a heart attack, and it impacts your ability to make decisions, or it causes you to be on a ventilator machine in the hospital. What do you want in that situation for you? Do you want to continue life support? Do you not? Do you want nutrition and hydration? Do you not? What are those things that you want for yourself as well if that event happened to you specifically? And then some of the other ones are what's called a power of attorney, which power of attorneys, I always kind of split them up into two different kinds. One is kind of a durable power of attorney, which is basically, if you can't make decisions about your money, who are you entrusting to do that? Right? Who is that other person that you're going to entrust to pay your bills and your mortgage and write your checks and those kind of things? And then the other one is what's called a healthcare power of attorney, which basically, again, if you're unconscious or not able to make your own medical decisions, who are you authorizing to make those medical decisions with your doctor? And so those are some of those advanced directives that you as a parent want to think about having in your kind of legal portfolio, as I call it, going forward for your kind of all the pieces that you want to include in your legal planning.
Do you also include that discussion for your child?
We definitely would. Again, and I just had this discussion with a mom yesterday on the phone. She was asking me about guardianship versus power of attorney. And I know we're talking about guardianship next time, so we won't go too much into it. But certainly, depending on the ability of your child, you may look at doing powers of attorney instead of doing full-blown guardianship. Again, and we'll talk about that during our next segment in much more detail. But on one hand, you may not need powers of attorney for your child if you're going to continue to be their guardian.
But this is a discussion that you help people walk through. They're not on their own when they work with you.
Right. No, definitely not. Definitely not on your own. Definitely very structured conversation to make sure that all these things are all these items are answered and then acted upon.
Mm-hmm. Ryan, is there anything else that you wanted to cover on today's topic? I know we're running a little bit late because of our technical issue.
Right. Sorry about that. You know, I think what I'd love to do is kind of lay it open for folks who are listening, like Sherry, and maybe they'll have some more specific questions. I know there's usually a lot of questions on trusts and things, and we can dive into a lot of detail here. So if we have folks who are out there listening to us or on the community that watch this later that have questions, please post them, and maybe we'll just we could always do another segment on this topic if we have enough questions to answer.
Right. Okay. Good. All right, Ryan. Well, is there anything else?
I think that's it. Again, I just want to say, you know, thank you to Keith and for everybody out there. Keith is, you know, he wasn't as talkative today, and not because he's not interested. He actually has strep throat, so you know, I'm trying to talk a lot, which I think I'm almost out of breath. But no, Keith, thanks for being here with your fever and your razor blade throat in there. So we appreciate you continuing to battle through and doing this. And for everybody out there, just so you know, Keith is a pioneer here in reference to he put failuretoplan.com together as a dad who had experiences with friends that had health issues, and all of a sudden he realized that, holy cow, us parents really need to figure all this stuff out, because if we don't, nobody does, and our kids are left in a way that we don't want to have happen. So to Keith, I appreciate him doing this. He doesn't, you know, he's not a planner, he's not an attorney, he's not a financial person, he doesn't get paid to do this.
Right.
So it's out of his, I think it's almost become part of his mission in life almost, and so I appreciate his pioneering spirit, and everybody else should too.
You know, Ryan, there is our next issue is on guardianship. I'm sorry, I'm sweating here. I got fever. Guardianship is our next topic, and I know that's a really big one for a lot of people because they don't understand what that means. So I'm really looking forward to that. So if you have any questions regarding guardianship, conservatorship, and powers of attorney, please be sure to go to the community and post your questions so that we can get them answered live on the next broadcast. Thank you. That's all. Thanks, everybody.
Yeah, thank you.